Back in 2020, the United States Postal Service delivered over 99 million ballots. 99.8% of them arrived within 7 days. That's a more reliable delivery rate than most pizza chains. Keep that number in mind, because everything that follows, the lawsuit, the Supreme Court ruling, the executive orders, the congressional standoff, is built on the premise that the system handling those 99 million ballots is so broken, so corrupted, so rotten at its core, that it cannot be trusted to deliver democracy. And the question at the center of all of it is a deceptively simple one. When exactly does an election end? On June 29, 2026, the Supreme Court of the United States gave its answer, and it was not the one the Republican National Committee, the Trump administration, or 4 of the court's 9 justices wanted to hear. Here is what happened, and more importantly, here is what it actually means. Because the ruling itself is only one layer of a much larger fight that has been building for years and is now heading directly into the 2026 midterm elections. Let's set the scene. Mississippi has a law, passed in 2020, that says absentee ballots are valid as long as they are postmarked on or before Election Day and received by local election officials within 5 business days after the election. Not 5 days to vote. 5 days for the mail to arrive after you already voted. The distinction matters. Mississippi is one of roughly 30 states with some version of this rule. 14 states and Washington, D.C. have similar grace periods for regular civilian voters. The law has been in place for years. Nobody called it controversial when it passed. Then the RNC sued. Their argument? Federal law sets a single election day, and that means every ballot must not only be cast, but physically received by Election Day. The Fifth Circuit Court of Appeals, one of the most conservative in the country and staffed in part by Trump appointees, agreed with the RNC. Mississippi appealed. The Supreme Court took the case. At oral arguments in March, things looked uncertain. 4 of the conservative justices were openly skeptical of the grace period. Justice Samuel Alito said the state's position raised difficult line-drawing problems. Justice Brett Kavanaugh, quoting a NYU law professor, warned that late-arriving ballots risk making the losing side cry the election has been stolen. The conservatives were lining up. The math looked bad for Mississippi. And then June 29th happened, and Justice Amy Coney Barrett, appointed by Donald Trump, confirmed to the court in 2020, wrote the majority opinion. She was joined by Chief Justice John Roberts and the court's 3 liberal justices, 5-4. Barrett's reasoning was precise and, depending on your politics, either obvious or maddening. Federal law sets Election Day as the deadline for voters to make their choice. That requirement is satisfied the moment someone marks their ballot and puts it in the mail. Federal statutes, she wrote, say nothing about ballot receipt. The deadline for when ballots physically arrive at an election office is a matter Congress never addressed. And what Congress never addressed, it never prohibited. In her own words, the question today is not whether an Election Day receipt deadline is a good or bad idea, but whether that idea has made its way into the United States Code. It has not. So states remain free to set their own receipt windows. Barrett also made clear what this ruling does not do. It does not permanently settle the question. Congress, she wrote, is free to pass a national receipt deadline if it chooses. The court simply isn't going to do Congress's job for it. Alito dissented, joined by Thomas, Gorsuch, and Kavanaugh in part. His argument? Accepting late-arriving ballots effectively postpones the date on which the electorate's choice is made, and the majority was operating under a flawed understanding of the Election Day statutes. He also warned the ruling creates a serious risk of further undermining public confidence in our elections. That last phrase, public confidence, is doing a lot of work in this debate, and it's worth pausing on it. Here's what the data actually shows on mail ballot fraud. Not the talking points, the data. Brookings Institution published a study in November 2025 analyzing confirmed fraud cases across 4 general elections, 2016, 2018, 2020, and 2022. Their finding, mail ballot fraud accounts for roughly 0.0000043% of all ballots cast. That is approximately 4 out of every 10 million mail votes. The American Statistical Association compared fraud incident rates in states with high male voting adoption against states with low adoption across 20 years of data. They found no evidence that voting by mail increases the risk of voter fraud overall. At oral arguments, Mississippi's own lawyer made a pointed observation. The federal government, despite loudly raising concerns about mail ballot fraud, could not identify a single verified example of fraud resulting specifically from a post-election day receipt window in this century. Even the Heritage Foundation, a conservative think tank that maintains the most comprehensive database of confirmed election fraud cases in the country, shows fewer than 100 cases of non-citizen voting between 2000 and 2025. Not 100,000, not 10,000. Under 100, over 25 years, across hundreds of millions of votes. None of this means fraud is impossible. What it means is that the scale of the claimed problem and the scale of the actual documented problem are not in the same universe. Which brings us to the phrase Alito used, public confidence. Because the argument is increasingly not about what is happening. It's about what people believe is happening, and what people believe has shifted. MIT's election lab data shows that belief in various forms of election fraud has risen steadily since 2016, even as the documented evidence has not. The perception and the reality have been moving in opposite directions for a decade. Before the ruling was even an hour old, Trump posted on Truth Social. He called it a tremendous loss. He said it is more important than ever to pass the Save America Act. He said the ruling gives people more time to vote illegally. So, let's talk about the Save America Act, because it is the second front in this fight, and it matters enormously for what happens in November. The House passed it in February 2026. The vote was 218 to 213. Every Republican voted yes. All but one Democrat voted no. The bill requires documentary proof of citizenship, a passport or birth certificate, to register to vote in federal elections. It requires photo ID to vote in person. It requires that people voting by mail submit a copy of an eligible ID with their ballot. And Trump has been pushing to add an outright ban on no-excuse mail voting to the legislation. The bill is now stalled in the Senate, and not because Democrats blocked it. It's stalled because Republicans themselves do not have the 50 votes needed to eliminate the filibuster. Senate Majority Leader John Thune has said clearly he doesn't have the numbers. Republican Senator Rick Scott delivered that message to Trump directly during a closed-door lunch. Republican Representative Thomas Massie, who has since lost his primary, put it bluntly, "I think it's ironic that we control the House, the Senate, the Supreme Court, and the White House, and we're yelling election fraud. We won all the damn elections." The opposition to the bill is not just partisan. The Brennan Center for Justice estimates that over 21 million Americans, nearly 10% of voting-age adults, do not have ready access to the documents the bill would require. That includes many elderly voters who were born before birth certificate systems were standardized, Native Americans on reservations without nearby DMV access, low-income voters, and rural communities across the country. Opponents argue it's not designed to stop fraud that barely exists. It's designed to make voting harder for specific populations. Supporters argue the opposite, that proof of citizenship and photo ID are common-sense safeguards, and that polling consistently shows strong public support for voter ID requirements, including among Democratic voters. A Pew Research poll found 83% of adults support requiring government-issued photo ID to vote, including 71% of Democrats. The argument over what kind of ID and what documents is where the fight gets real. A driver's license is not a birth certificate. Many Americans have one, but not the other. The bill's critics say those distinctions are the point. Here is the part of this story that has gotten the least attention, and it might matter more than the court ruling. In late 2025, the United States Postal Service made a change to its mail pickup operations. In rural areas more than 50 miles from a regional processing center, the number of daily pickups was cut from 2 to 1. The effect is straightforward. Mail dropped into a rural mailbox in the afternoon may no longer be processed, and therefore postmarked until the following day. In a grace period state, that postmark is everything. If a ballot is mailed on Election Day but postmarked the day after, it may not be counted. Even under today's ruling, the Supreme Court upheld the grace period. It said nothing about whether the Postal Service has to cooperate with it. Election officials at a conference in Virginia this past February were already raising alarms. The conference included an entire session on the new USPS policy. One official compared it to the tax deadline problem. The only way to guarantee a mail-in ballot is postmarked on a specific day is to take it to a post office and request a manual postmark in person, a step millions of rural voters have no practical way to take on Election Day. A VoteBeat analysis found that at least 750,000 ballots eligible to be counted arrived after Election Day in 2024. Those ballots were cast by voters from both parties, in states across the political spectrum, who followed every rule in front of them and trusted the mail to do what the mail has done for over 150 years. The USPS change makes that trust structurally harder to justify. A D.C. Circuit Court ruling on the USPS change is expected this summer, potentially just as states begin preparing and sending out midterm ballots. So, here is where things stand. The Supreme Court has ruled that states can count mail ballots that arrive after Election Day. That law remains in place in 14 states and D.C. for the November midterms. The Save America Act has passed the House and is stalled in the Senate. It is unlikely to become law before the election. But Trump has made it a condition for signing other legislation, which has already disrupted a bipartisan housing bill, a surveillance reauthorization, and several other priorities. The bill's fate is being used as leverage well beyond its own merits. 4 Republican-led states eliminated their grace periods entirely in 2025, before the ruling. Mississippi's governor, a Republican, has suggested the state legislature should repeal its own law regardless of the court's decision, and require all mail ballots to arrive by 5 p.m. on Election Day. 9 states enacted 12 new restrictive voting laws through May 2026. At least 41 states considered over 300 restrictive voting bills this year, and somewhere underneath all of it, the Postal Service is running fewer pickups in rural America, and the courts have not yet decided whether that's allowed. There is something structurally interesting about where this fight has landed. The 2020 pandemic produced a surge in mail voting. In 2020, roughly 43% of voters cast their ballots by mail, twice the rate of 4 years earlier. By 2024, that number settled to about 29%. 1 in 3 midterm voters now votes by mail, according to the MIT election data and science lab. Mail voting has been growing steadily across both parties for over a decade. States that implemented universal mail voting have some of the highest voter participation rates in the country. The infrastructure for it is deeply embedded in how American elections actually function. The fight to restrict it began in earnest after 2020, accelerated by Trump's repeated and unsubstantiated claims that mail voting was the mechanism of his defeat. But what the data shows, and what the court case in Mississippi forced into a legal record, is that the claims of fraud have never matched documented reality. Mississippi's lawyers said it plainly. The government raised the anti-fraud argument. It could not show one actual case. What is left then when you strip away the fraud narrative? You're left with a structural argument, that elections should feel decisive on election night, that prolonged counting creates uncertainty, and that the appearance of integrity matters as much as its presence. Some people find that compelling. Others find it a reason to change what people see, not what is happening. Barrett's ruling in the end bounced the question to Congress. Here is the legal line. If you want a receipt deadline, Congress must draw it. The court will not. Congress, for now, has not drawn it, and it probably won't before November. The 2026 midterms will determine which party controls the House and the Senate. Control of Congress shapes every investigation, every legislative agenda, every check on executive power for the next 2 years. The fight over how ballots are cast, received, counted, and challenged is not a peripheral issue. It's the mechanism. 750,000 ballots arrived after Election Day in 2024 and were counted under existing grace period laws. Those laws are intact today. Whether they remain intact, whether the postmarks are accurate, whether the USPS cooperates, whether the Save America Act finds a path, none of that has been settled. The court ruled. The fight didn't end. That's Fenn for Borderlines. Analysis from the edge. If you found this useful, the channel's just getting started.